This video will cover what can be done in a situation where a possession claim has been issued based on a Section 8 notice, and perhaps the tenant or the judge is raising an issue as to whether the Section 8 notice is defective and the consequence that that might have on the claim for possession. Even if the Section 8 notice is defective, all is not lost. The court does have a power to still consider the claim and make a possession order. A Section 8 notice is a notice seeking for possession of property. It can be served for many different reasons. These reasons are known as grounds for possession, which are set out in the legislation. The most common grounds for possession relied upon are the non-payment of rent and antisocial behaviour. A Section 8 notice must be served and it must be valid in order for a landlord to issue possession proceedings based on any of the grounds for possession. One of the most common reasons a possession claim fails is because of a defective notice, and the landlord or landlord representative does not know of the arguments in support of the court making a possession order, whether that is an argument to hold the Section 8 notice as valid despite any errors that may be contained in the notice, or whether that is asking the court to exercise a power that it does have to consider the claim even if the Section 8 notice is in fact invalid. In 2020, the Court of Appeal made an important judgment. What it held was that something called the reasonable recipient test applied to notices seeking possession, specifically the Section 8 notice. And what this meant was that if, notwithstanding any errors or omissions on the Section 8 notice, the reasonable recipient, i.e. the tenant, would be left into no doubt as to the terms of the Section 8 notice, the notice would be valid. Now, using a very simple example in which a tenant could argue that the Section 8 notice is defective, and a landlord could rely on this Court of Appeal judgment to say to the judge that actually this notice is valid despite the errors contained within it. So the example that I will use is a Section 8 notice is served on a tenant based on rent arrears. The Section 8 notice itself does not state what the amount of unpaid rent is at the time the notice is served, as it should do. The tenant argues that because of that, because the Section 8 notice does not state the amount of rent arrears that are outstanding, that the notice is invalid. But let's say this notice was served with a covering letter, and the covering letter did state to the tenant what the rent arrears were. In those circumstances, the landlord could argue, based on the Court of Appeal judgment, that notwithstanding the errors contained in the Section 8 notice, the tenant could not be left into any doubt as to what the rent arrears were, because they were separately informed as to what the rent arrears were at the time the notice was served. And in those circumstances, it's highly likely the court would hold that despite that error, the Section 8 notice is valid, and that it would then make a possession order if it's satisfied the rent arrears are as claimed. Now let's go a step further and say that a completely invalid notice has been served on the tenant. Let's say the notice fails to state the grounds for possession that are relied upon, or for one reason or another, the notice is invalid and there's no arguing otherwise. The court does have the power under Section 8 of the Housing Act 1988 to dispense with the requirement to serve the notice altogether. In other words, if an invalid notice has been served, the court can still make a possession order based on a ground for possession if it is satisfied that it would be just and equitable, and that's the wording from the legislation. The court must be satisfied that it is just and equitable to waive the requirement for the Section 8 notice to be served. Now, if a court is satisfied of that, the landlord cannot rely on a mandatory ground for possession. The court can only consider the claim under a discretionary ground for possession, and that is simply because the court is exercising its discretion to waive the requirement for the notice to be served. And in those circumstances, it would be entirely at the court's discretion as to whether it finds it reasonable to make an order for possession. So there are two well-established things that can be done in relation or in response to an allegation that a notice is defective. You could firstly argue the notice is valid in relation to the reasonable recipient test, holding that the tenant could be left into no doubt as to the terms of the notice. If that argument fails, the court should be invited to completely waive the requirement for the notice to be served and to still consider the claim. So this shows us two very important things. Firstly, get the Section 8 notice right from the beginning. It avoids these costly disputes, which also cause delays in getting an order for possession if a possession order is made. The second thing it shows us is that all is not necessarily lost if a defective Section 8 notice has been relied upon. If you're a landlord and you find yourself in that situation, it's very important to seek legal advice and representation from somebody who specialises in landlord and tenant law. These arguments can be advanced and you may well be able to save your Section 8 notice and get a possession order depending on the very specific circumstances of your case.